Chairman, without objection, I would like to place a budgetary impact by Michael Salon, the former senior advisor to the Senate leadership, in the record. I'd also like to place in the record, without objection, a report from the Council for Citizens Against Government Waste and a letter from the mayors of Arizona regarding this legislation.
Without objection, so ordered.
Mr. Speaker, House Resolution 308, the Keep the Promise Act, seeks to prevent Las Vegas-style gaming in the Phoenix metropolitan area until the gaming compact to which tribes agreed and the Arizona voters approved expires in 2027. One Tucson area tribe is trying to build a major casino on lands that were deceptively purchased in the Phoenix metropolitan area at the very time that they were in negotiations with other tribes in the state to craft this gaming compact duly passed by the voters. These actions are contrary to the public commitments that this particular tribe made between 2000 and 2002 to the other 16 Indian tribes in the state of Arizona, and also to the state voters of Arizona. This legislation was then publicly supported by the passage of Proposition 202, this compact, a state referendum to limit casino gambling in the Phoenix metropolitan area. All parties knew what we were agreeing to, Mr. Speaker. Mr. Speaker, the bipartisan co-sponsors of H.R. 308 are simply trying to hold all the parties to their publicly stated commitment to the people of Arizona not to engage in gaming in the Phoenix metropolitan area. Contrary to the opposition's position, Congress does have a role in supervising tribal gaming. Congress has a long-established history of regulating, managing, and working with the tribes relative to tribal trust lands. Most astonishing, Mr. Speaker, is the opposition's argument that the courts have, quote, upheld the tribe's right to operate a casino on that parcel of land. Indeed, the court raised serious questions about the tribe's misconduct, but dismissed the litigation under the doctrine of sovereign immunity. This is not a ruling on the merits in favor or against any side, Mr. Speaker. It simply means the court could not or would not issue a ruling. This bill passed the House twice before. It had a 0 CBO score. In CBO's analysis of this exact bill last Congress, they acknowledged the uncertainty of future legal challenges, but did not score those. This is the standard practice. Today, any ruling by them to the contrary is a precedent and sets the CBO up for being politically impacted in the future, politically driven in the future. Astonishingly, the CBO recently scored an addition to the exact same bill this Congress scored, the CBO scored of $0 to $1 billion. Let me say that again, Mr. Speaker. The CBO added a score now to this same bill from 0 last time to now 0 to $1 billion. Now, of course, they were lobbied to do that in an unprecedented way, while admitting it had no basis to issue any conjecture about a possible lawsuit resulting from the passage of this bill. CBO admits it had no basis to score litigation. The CBO has never scored potential litigation on other bills, and this score should be ignored as useless and harmful if allowed as a precedent, Mr. Speaker. This bill does not impact any tribe's ability to have lands taken into trust, nor does it impact any water or land claims. Consistent with the intent of the Indian Gaming Regulatory Act and of Proposition 202, this bill merely restricts the ability of tribes to game on the very lands on which they themselves agreed they would not game. With that, Mr. Speaker, I respectfully ask that my colleagues join with me today and the members of Arizona's delegation in supporting this bill.